Today's date is March 1st, 2022, and as you can see, this morning's panel is Judge Hensel, Judge Sutton, and myself. I'm Judge Teodosio. I will be presiding. This morning, we are going to hear arguments in two cases. They will be case number 20CA011695 and 20CA011694. I know the parties have filed a joint motion to adjust the order of the cases, and the court has approved the following schedule. We'll start first with Appellant for Elyria's presentation of their argument on your assignments of error 1 through 4, and then on Brexton's cross appeal. So we'll hear first from you, Attorney Murphy. Then at 11:45, you'll have 15 minutes now. And at 11:45, we're going to hear Appellee Brexton's argument on for Elyria's assignments of error 1 through 4, as well as Brexton's cross appeal. So Attorney Gamble, you'll follow Attorney Murphy. That'll take us up to noon, on or about noon, where Appellant for Elyria and David Thomas will present their argument on assignments of error 5 and 6. So Attorney Murphy, you're representing Mr. Thomas, correct?
Yes.
Okay, let me make a note of that. And then finally at 12:15, Appellee Protective Life Insurance, Attorney McMillan. We will listen to your argument on assignments of error 5 and 6.
Thank you.
All right, everybody agreed on that schedule, so we're going to follow that, okay? Everybody okay with that? Very good.
Yes, Your Honor.
Yes,
All right, as we noted, it's probably helpful if you mute yourself when you're not speaking so as to minimize any potential distractions. As you can tell and are well aware, the arguments are being recorded. They are posted on our YouTube channel as soon as possible after they are completed. You should know that I know Judge Hensel, Judge Sutton, and I have spent a lot of time reading your briefs, and we're prepared to proceed if you are. So as I said, we will start off with Mr. Murphy on behalf of for Elyria on your assignments of error 1 through 4. So, as well as on Brexton's court cross appeal. I'm sorry. So go ahead, Mr. Murphy.
Thank you, Your Honor. If it pleases the court, John Murphy on behalf of both For Elyria Company and Mr. Dave Thomas. I would like to reserve 5 minutes of my time for rebuttal at the end of this argument.
I think you're going to go from 11:30 to 11:45. I think we're going to do 15-minute arguments without rebuttals, as was my understanding.
I believe that the email that came out gave me the permission, as your order or as your rules permit, to do a rebuttal.
So you'll do?
I will do 10 minutes essentially.
I just want to make sure everybody's in agreement on the process. Any comment on that, Attorney McMillan or Attorney Gamble?
No objection from Protective, Your Honor.
No objection, Your Honor.
All right, very good. I'll let you know then when you get to the 10-minute mark, Attorney Murphy.
So I'm going to about to 11:48.
Let's see. I would say that's about right. That's correct.
Thank you very much. If it pleases the court, I'm going to primarily focus on the contract for construction of the Chestnut Commons development. The reason I'm going to focus on the contract because it warrants reversal. The reason I'm going to concentrate on the contract because at the end of the day, it really is a simple case. It may be a complicated contract, but the concepts and the legal issues are simple. It's the age-old conundrum that all of our courts in Ohio have faced numerous times: construction change orders. It gives everybody a headache when you just hear those words. But here we go again. If you look at Foster Wheeler, Dugan Meyer, plus this court's decision in the Champion contracting case, the answer becomes simple. By the way, there's a number of issues that I'm not intending to raise at all orally. I don't want the court to take that as a waiver of those issues. Time is such, and this issue is going to take my 10 minutes, so I want to concentrate on the contract. The issue before the court. So we know that it's a real estate commercial development with 4 retail stores. And the question before the court is whether or not the tenant improvement project for the Petco tenant is a part of the contract or not. Brexton claims that it was not part of the contract. Let's discuss and review the contract to see if that position is accurate. The first thing that I'd like to do is take a step back and talk about how these contracts work. We've all had sort of the simple contract, like the Champion construction case, where it was just two small parties, probably a 1-page document. This is a very unique contract. It's relatively new. There's not a lot of jurisprudence on it. It's called Construction Manager at Risk. Construction Manager at Risk. It is a guaranteed maximum price contract. It's published by somebody called the Consensus Group, and it's sort of taking the place of AIA in the commercial construction area. But what's different about a Construction Manager at Risk GMP contract, that's the whole name, Construction Manager at Risk GMP. I'll just call it the GMP contract. But what's unique about it is that it recognizes in commercial projects, the project is fluid. What does that mean? That means that we can fast track projects by starting construction before we finished our design work. And it's very, very common. The larger the project, the more likely you're going to start the project and design it as you go along. So this is a fast track project. The contractor can start working immediately. The reason we call it, the reason Consensus calls it a Construction Manager at Risk is because in this case, in this contract, it's very unique. The construction manager manages the entire project. There's not an architect on site day in and day out. There's not an owner on site day in and day out. The construction manager manages the schedule, obviously the construction, but also the budget. That's what they mean by at risk. It's a financial risk that they place on the construction manager, hence the name manager. You manage the project, you manage the price. So the GMP means that it's going to not exceed a certain value. In this case, it was roughly $2.4 million. The contract is very specific. The plans and the specifications are incomplete, but the contractor still has to give a price. I compare it to when you take your car into an auto shop and it says, I don't know what's wrong with your car. It might be this, might be that. I think I can get it done for this, not to exceed price. And that's what the contractor does in this case. They know everything about the project that is available to be known, and they give you a price, and they're not going to exceed that without going through the change order process. We cited an article that says roughly 60 to 90% of the project is designed typically when you start those. If you accept Brexton's math, it was about 90% planned, drawn, and specified before they signed the GMP. So let's talk about the GMP. That's a general term of how this type of contract works. Let's talk, and I apologize, I'm very dry. I'm going to reach for the water once in a while. I apologize. Let's talk about specific contract provisions then, and we can see how this design process works. The most important contract interpretation rule to remember as we go through this is this concept that we give effect to the entire contract, to all provisions. And the reason why I introduce the contract analysis with that is because we believe that if you accept Brexton's reading of the contract, that in fact, you have to ignore a lot of provisions, a lot of words, a lot of phrases, a lot of things are at risk or are on point in this case. But anyway, if we give effect to all provisions of the contract, you will see that the Petco work was part of the project. So what contract provisions do we want to look at? We start with the very first page of the contract, not the cover page, but the first page inside the cover. They define the project. You define the project, and once you define the project, you define everything that flows from the project. And the project is, and this is Exhibit 13 in the depositions, it's Chestnut Commons. That's the project, Chestnut Commons. It's 2,600 square feet of retail center. Nothing more, nothing less. So what all does that mean then? One would suggest that it's everything at that address, but we can go to more provisions. We can look at the shell building was drawn before they signed the GMP, and the notes on this shell building specifically say, they use the word capital P project, which is a defined term in the contract. The capital P project means not just the shell, but the tenant improvement work that the landlord's required to do, which is for Elyria. There's no exceptions to the definition of project. It's black and white in the contract. No exceptions whatsoever. Let's go to the next provision. Under 2.3.27, they define work. What is the work that the construction manager is going to do in the contract? The work is defined as everything incidental to the project. Back to the address, back to the word project, work is everything incidental to that. The only exception, and this is important because when the drafters of the contract put one exception in, don't put other exceptions in, there is only one exception. There's one exception for work that's done by others. So if another contractor came in and did something different, then that would be accepted from the work under the GMP. But in this case, it was not. So we know that it's everything incidental. That's a key word. We're going to look at the Champion case when we're finished with this. We're going to see how the Champion case dials back with these words like incidental, okay? Article 3. Article 3 is the CM or the construction manager's responsibility. It's 14 pages long, it's cumbersome, and there's a lot of provisions that have a lot of phrases that would be ignored under the Brexton analysis. I can't read them all. We don't have time. But Article 3 demonstrates the fluidity of the process. The drawings are coming in as the construction is going on. It's a very fluid project. Article 3.1.1, first part of Article 3, again, it further defines the word project and the word work. And it says, what is your responsibility, Brexton? Your responsibility is the work in the project. Everything that's inferable. It's another key word, inferable. So it's incidental, it's referable, it's in the project. Article 3.3 is primarily pre-construction services. What does that mean? If you haven't started the dollar value TI work, then the pre-construction services section tells you what to do on that. If you haven't started the Petco TI work, then the pre-construction services tell you what you do on that part. And again, time and again, they recognize and they make the contractor acknowledge that the design and the drawings and the specifications aren't done. It's a moving fluid project. 3.3.4.2, budget adjustment, 3.3.4.4. If changes in documents require changes in budget, let us know. And on
Attorney Murphy, I just have to let you know you're at the 10-minute mark. You check your clock, you're at 11:48. Would you like to continue and eat into your rebuttal time or stop at this point?
No, there's a lot of contract provisions on point. They're largely discussed in the brief. Thank you.
All right, then you'll have 5 minutes after we hear from Attorney Gamble. Just give me 1 second, reset this timer, sir. Okay, whenever you're ready.
Thank you, Your Honor. Good afternoon, Your Honors. John Gamble on behalf of Brexton Construction LLC with my co-counsel Pete Moline watching in the wings today. For Elyria had spent almost its entirety of the oral argument to say not much that matters specifically as it relates to this particular contract, and instead has talked about general industry principles and delivery methods, which in all reality and as they've been portrayed by Elyria in this proceeding do not relate to this particular contract, or at least do not specifically, they aren't looking at the actual contract language and the contract terms that are involved in this case. The trial court got this correct when it looked at the totality of the circumstances, looked at the language chosen by the parties in the contract itself, saw that the parties specifically did not list the Petco prototype drawings as being included in the scopes of work. They didn't include any kind of a reservation or any kind of a note in the assumptions and clarifications or anywhere else in the contract to provide that the Petco tenant improvement work would be performed and is included within the guaranteed maximum price. There simply was no reference to the Petco tenant improvement work that ultimately was performed by Brexton, to the tune of approximately $500,000, which Elyria has refused to pay, despite the fact that everybody involved knew that Brexton was going to be performing that at some point under a separate agreement outside of that original GMP agreement. With regard to the idea of the construction manager at risk and the involvement in the design process, the statements by Elyria to that effect belie the facts of this case, as well as the testimony that has come out through the course of depositions, and frankly is a brand new position that they've taken on appeal with regard to explaining why Brexton should have been, I guess, more, as Mr. Murphy put it, fluid when in their assessment of the work to be performed under this contract. The fact of the matter is there were specific drawings and pages listed in the contract, in the addendum. There were assumptions and clarifications, and you have to look at all of those things whenever you're determining what is the work that is going to be performed by the general contractor, and two, how much is the general contractor to be paid for that work? And that is what the Foster Wheeler case actually got to, is that you should not look at the industry standard or the general principles of construction when determining what contracting parties meant when they entered into a contract at the time of the parties at the inception of the contract. That each contract must be looked at on a case-by-case in a contract-by-contract basis to determine what exactly the parties intended whenever they entered into that contract. And the contract, as you look through it, specifically does. I mean, I'll agree with Mr. Murphy to that point, that it is very clear when you look at the contract to determine what was to be performed by Brexton. And there simply is no reference to the Petco tenant improvement work that was ultimately performed. And that is what this entire case rests upon. Once the court looks at the contract, the fully integrated contract, which states that there are no agreements, no assumptions, no representations that are to be taken to be a part of this contract other than what sits inside those four corners of the document. Once the court were to look at those, I think that the court will find and should find that the trial court properly examined this contract, found that the parties did not intend for the Petco tenant improvement work to be covered within that original GMP agreement, and ultimately then found that Brexton was able to pursue recovery under an unjust enrichment theory of recovery. The only Petco tenant improvement work or drawings that were shown or were in existence at the time that the parties entered into the contract were prototype drawings, which were not referenced in the contract, that Elyria's own architect stated should not be used, or they would not anticipate contractors using those to develop pricing or to build the project, because they were not site specific, were not referenced in the contract, and simply could not be used for purposes of pricing. So at the time that the parties entered into the contract, and entered into a guaranteed maximum price contract, that GMP agreement. There were no drawings upon which Brexton could have priced that work. So there simply is no way for Brexton to have included that within its price, barring something in the agreement affirmatively stating that this GMP work included documents or included pricing for work that was shown on documents that otherwise were not referenced or a part of the contract at that point in time. And that is, when you have a fully integrated agreement, such as we have here, you can only incorporate ancillary documents through specific references, not the vague references and the general references upon which Elyria is attempting to use to shoehorn this Petco tenant improvement work into the contract. Beyond just the language of the contract itself, when it comes to the listing of the contract documents and the drawings and the specifications, you must also look at what the trial court looked to on the first sheet of the plan drawings that showed the shell work, which indicate that the project consisted of shell building and landlord's TI work, and that tenants' TI work was to be submitted under a separate contract. The tenant's TI work that was supposed to be submitted under a separate contract is that Petco tenant improvement work. Now, I know Elyria has attempted to say that landlord's TI work somehow includes the Petco tenant improvement work, and that Brexton should have been aware of that work to be performed. But the fact of the matter is that any landlord obligations shown under the lease between the landlord and Petco, that's not a contract document either. Those documents aren't referenced in the GMP agreement between Brexton and Elyria. There was no addendum to the agreement which provided an itemization of landlord's TI work that Elyria somehow claims included that $500,000 in Petco work that Brexton ultimately performed and was not paid for. So that argument on Elyria's behalf simply falls flat. Further, with regard to this idea of a complex agreement that we're dealing with here, it's simply not the case for the parties involved in this action. While Elyria is a single purpose entity for purposes of constructing this one particular project, the underlying folks involved here are sophisticated developers with a practicing lawyer at the helm who was involved in the negotiation process of this contract. Dave Thomas was served, and there is evidence in the record and communications where Dave Thomas reviewed the contract documents before they were signed. And as a practicing real estate lawyer, if there were any ambiguities or anything that he was concerned with at that point in time, then the time to clear those up was at the contract's inception. And Elyria was in a position at the time of bargaining to make sure that if it felt like the Petco tenant improvement work, as shown on the prototype drawings, should have been included, then they could have very well been listed just like all the other drawings that were specifically called out. And under the general rules of contract construction, the specific listing or inclusion of one thing operates to the exclusion of others. So the fact that the parties took the effort to specifically list out all of those contract documents and drawings, the fact that the Petco tenant improvement drawings, or even the prototype drawings, which were the only ones in existence at that point in time, since those were not listed, the court has to look at that and look at the parties' actions in that regard. And the only reasonable conclusion is that the parties didn't intend for those drawings to be incorporated into the agreement. Once the court determines that fundamental question and answers that fundamental question as to whether or not the Petco tenant improvement work was included within the parties' agreement, the rest of, and once the court, and I believe that the court should find that the trial court got it correctly in that regard, that the rest of the cards of Elyria's House of Cards argument fall. All of the assignments of error 1, 2, 3, and 4 all hinge on that single question. And so once the court answers that question answers the question and finds that the Petco tenant improvement work was not included in the parties' contract, then there is the only finding for the court to have at that point in time is to find that the Elyria's assignments of error are not well taken. In my last few minutes here, I'd like to address Brexton's cross assignment of error with regard to the awarding of attorney's fees. Just briefly, it is reviewed on an abuse of discretion standard, but we would ask that the court find that the trial court abused its discretion in denying Brexton's motion for attorney's fees under the prevailing party provision of the party's contract, finding that one of the reasons being that you have to look back at why these costs were incurred in the first place, and the party that really thrust everyone into this litigation being for Elyria when it raced to the courthouse and filed not only breach of contract actions against Brexton, but also filed individual actions for fraud and other misrepresentations that were claimed by For Elyria against Brexton's officers and shareholders, Mary Beattie and Tim Galvin. It was For Elyria that thrust this case into the world of litigation and caused all these costs to be incurred. And Brexton was ultimately the prevailing party at the end of the day. And as a result of being the prevailing party, Brexton asked for the court to award it attorney's fees in that regard. And not just some blanket award of all its fees and costs. Brexton went through the painstaking task of parsing out those fees that are just strictly attributable to defending the breach of contract action brought by For Elyria. Had an expert in line to testify as to those fees and an affidavit that was submitted along with the application for fees that itemized those costs. We would ask that the court reverse the trial court's decision in that regard and find that the trial court erred in not awarding Brexton its fees, and also ask that this court at the end of the day uphold the fundamental and the seminal issue, I guess the court's decision on the seminal issue of this case, which ultimately warranted summary judgment in Brexton's favor. If the court does not have any questions at this time, then I would conclude my argument.
Judge Hensel, any questions for Attorney Gamble? What about you, Judge Sutton? No? All right, thank you very much for that argument. And Attorney Murphy, you've got your 5 minutes. You're on mute, though. You're on mute, sir.
There we go. I'm in a fancy video room. I don't know how to run it yet.
All right, we'll give you 5 minutes from now. Go ahead.
Thank you. To suggest that this is the prototype specifications that were given to them about 8 weeks before they signed the guaranteed maximum price contract. To say this was an idle exercise is an absurd argument. This is not a paperweight. These are specifications by Petco, just for the Petco TI work. About 2 months before the contract, Pontia Exhibit 129 says, put these in a Dropbox for pricing. For pricing. That's why they were provided to Brexton at that point in time. The contract 3.4.5 is on point. If the plans aren't final, they're not. It's a prototype. They're not final. If they're not final, 3.4.5 says you, the contractor, will allow for that in your budget. That's all. So when the final came out, if they had to adjust the budget, adjust the budget. That's how this particular contract works. It's one leads to the other, leads to the other. One of the best examples, nothing's showing up here. Exhibit 22. Exhibit 22. The Brexton people in February of 16, the contract is just started. They're saying, where's the final? Where's the final? Why are they asking for the final 1 month into the contract if it's not part of the contract? It clearly is. What's absurd about this Exhibit 22 is stop and think about what Brexton's saying. They're saying that there was a $500,000 contract that was in place for over a year. Nobody wrote a note about it. Nobody said a word about it. There's nothing anywhere. There's 44 pages on the first contract. nothing about this one. And then surprise, 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 about 4 or 5 months after this construction was finished, Brexton said, oh, by the way, owe us $500,000. It was a surprise. That's exactly what the contract is designed to avoid, and exactly what Foster Wheeler suggests is the right way to go. I cited the Champion case from this court, and because the language in the Champion contract is insightful. You use the word deviation. If you deviate, it's additional work. I say that's important because listen to the language in this contract. If it's incidental, if it's inferable, if it's within the general scope, you got to have a change order. They didn't do the change order. They're not entitled to an oral contract for $500,000. Common sense, I think, puts that to bed. After the construction started, they kept asking for the plans, but they also asked for the lease. And that's an odd request, isn't it? How many people have had work in a rental facility and the contractor doesn't say, hey, what's your lease say? It matters because the lease ties back to the construction. The lease required the landlord to do certain improvement work. The improvement work is in the plans, which is a part of the project, which is in the contract. It all ties together. And they knew that. They simply held on to $500,000 and tried to get an oral increase. And if you read the language from Foster Wheeler, it's right on point. That's exactly what we're not supposed to do in construction cases. I submit to the panel that if the court grants judgment in favor of Brexton, it's a floodgate situation with oral contracts in construction, because this contract is better than Foster Wheeler. It's better than Champion. And it's going to be floodgate litigation because every contractor is going to say, oh, gee, don't forget, we have an oral contract. Any questions? Now I finished early on that part of my presentation.
Well, let me check. Judge Hensel, any questions? And Judge Sutton. All right, thank you, both of you, for very good arguments this morning on those assignments of error. Now we are going to move on to Appellant for Elyria and David Thomas's argument on assignments of error 4 and 5. That, of course, will be you again, Mr. Murphy. Do you want to split your time on that one as well?
Yes, please, if it pleases the court.
Do you want 10 and 5, or how would you like to divide that?
10 and 5, if it pleases the court. Yes, please.
All right. Let me just refresh my legal pad. I'll be right back.
But that's what I was just doing. It's moments like this I have sympathy for the court, because you can hear a lot of arguments in one day and keep it all straight. I'm just going back to back, and it's just.
All right, I'm ready when you are, so you may
Thank you,
start.
Your Honor. I have about 1207.
Right.
So this is another breach of contract provision, or another case, another different contract, different parties. Protective Life is suggesting that for Elyria and Dave Thomas both breached the loan agreement in 2 areas. I'm going to discuss those 2 areas first and why their argument is invalid, but there's also a common element that flows from both of those breaches, which I will also address if it pleases the court. The first one has to do with what they call the subcontractors on the project. They're trying to prove fraud and misrepresentation by for Elyria. They're doing that by trying to get into Mr. Thomas's head. As you know, he's a real estate lawyer. He's the lawyer for the company. He reads and signs their contracts. That's his job. And they want to get inside his head to prove fraud and misrepresentation. And they identify issues with subcontractors. And the first point that I'd like to make is it's shockingly misleading what they gave the court. They gave the court this huge list of what they said was problems with the subcontractors. But what matters is a narrow point in time when DNA Plumbing and Space Comfort said to the owner, oh, gee, can you talk to the contractor about getting us paid? Those are the only 2 that matter. So let's first set aside that long list. Recognize the personnel from for Elyria. For Elyria had a guy, boots on the ground, named Grant Giltz. What's his job? His job is to make sure the contractor's doing the work that the tenants can then move in on a timely basis. Petco wants to be in by Christmas, November of 16. So it's important. So Grant's on the job site. Dave is the lawyer. Dave's not on the job site. Dave's the lawyer. He reads and signs the contracts. Brock Walter, you've heard that name. He's the money guy. He watches the bank account and he signs the checks. Those are the personnel that matter for this issue. So we know that we've got 2 subcontractors that reached out. This is common on contract construction projects because subcontractors oftentimes are being paid slowly. That's up to the contractor. And they think that the owner can put pressure. So they're just trying to leverage. And to that point, Grant Giltz went back to the contractor and said, hey, I'm getting these calls from DNA Plumbing, Space Comfort. Please, if you would, see about getting them paid. So what's Dave's knowledge? When Grant Giltz gets this thing, I'm sorry, that's not knowledge of anything having to do with the lending. He's just doing everyday projects that you do when you have a construction contract. He's dealing with people. It's not his job to report it to the company. His knowledge, whatever it is not imputable back to the company. But the company does have knowledge. And this is really bizarre. Nothing shows up on the camera. Oh, that's right. This is Exhibit 50, okay? This is the company's knowledge. This is the only document that actually goes to the company that shows the company's knowledge. What is this? This is called a pay application. If you've had construction litigation, you know what a pay application is. Periodically, the contractor says, here, pay us some money, pay application. They had 2 at the end, what they call the final, and the next one is releasing the retainage. This is on the retainage. This is a notarized statement from the contractor, representative Mary Beatty. Listen to what Mary Beatty says. We waive, release, quit claim in favor of the owner or owners of said real estate in favor of each and every party making a loan on said real estate. So Brexton signs a statement it's November 30th for the owner, for the lender, that says we're paid in full. There's nothing left to do. No people left to pay. And it's even broader than even the GMP, right? Listen to what it goes on to say, upon the capital P project, we know that's a defined term in the GMP, upon the capital P project or any portion of the lands of owner or buildings thereof. So I don't care if Petco's out of the contract. They released all claims under oath. Now, that's the company knowledge. So Mr. Thomas, in February, is presented with the documents. He doesn't know about the 2 issues that Grant dealt with. Doesn't matter. That's clear. The testimony is clear. Grant never told Dave, right? But Dave, there's also one other thing that's not on Protective's list. It's the reverse of what they're saying. In January, one of their subs did lien the property. Griffith Paving liened the property. That's Exhibit 53 in the documents. Brexton paid it. Before Dave signed the loan agreement, Brexton stepped in and solved the problem. So what do we know about DNA or Griffin or anybody else? As far as we know, the problem's been solved. What we also know is the contractor told us under oath that everything is taken care of. You have to do a double imputation, and the only knowledge we know is this. You got to take Grant's knowledge to the company over to Dave. I don't believe that the law supports that. So I don't believe that there's any breach with respect to issues with a couple of the subcontractors. Bonding, that's another issue. This is disappointing too. The list was disappointing. This is even more disappointing because remember, they're a lender. If you see the document in the file, it's a humongous promissory note. It's your typical commercial loan, very, very detailed. Their document construed against them. Their contract very clearly says that Fort Elyria has the right to challenge the liens. 4.1 parentheses D and 4.1 parentheses E says that. And that's what Fort Elyria was doing, by the way. When the lien went on from Brexton, Fort Elyria filed a lawsuit to remove the lien. and also to claim fraud because of the fraudulent statement that was made in the lien app or the pay application. But they wanted to clear the title, and the document gives them the right to do that. Now, what Protective is trying to do is take the next section that talks about operational expenses and tie the two together. That's not what they do. In 4.1D, property liabilities is a defined term. Read the contract, Protective. We can fight those liens if they're the property liability. It's black and white in the contract. Real quick, why is maintenance and operation different than construction? Think about it. If an owner does construction, they're improving the property, aren't they? Theoretically helping the bank by increasing the property. If they're not doing their maintenance, on the other hand, we know it's going down the tubes. So it makes sense that they would have two different provisions, two different expenses. You can fight one and not the other. So the contract gives them the right. Lastly, what's the last element in a breach of contract case? Damages. Step back. Where's their damages? It's clear on the record. Elyria has not missed a payment on its mortgage, not one. Not in default of anything in the note mortgage at all, other than these two small issues, right? That they're claiming. Taxes, maintenance, everything is being done properly. Protective has the first and best lien. Protective's lien is collateralized in spades. Yet it's in the record. If you take their attorney's fees claim, Brexton's claim, Protective's loan, and you add it all up, there's still something like $1 million in collateral left behind. So their lien is first and best. Their property's heavily collateralized. They have the right, by the way, under the contract, like all commercial lenders do, to come in and take the rents if they want. But they haven't done that. They haven't foreclosed. They haven't accelerated. They haven't done anything to collect the note. They haven't taken over maintenance. They have a right to do that. They've not taken any effort at all. They've not had any damages from the giving the loan, not one. These two issues with the subcontractors, they didn't lien the property. They didn't file a lawsuit. They're not in privy contact with us, so they can't sue us directly. They're way past their lien rights. That hasn't damaged them, nothing whatsoever. I would suggest that Brexton suing them maybe caused them $200 to put an answer on, but that's all. That's the only damage. We're here with Protective because they have $250,000 in legal fees.
Attorney Murphy, you're at that 10-minute mark, so you can continue or reserve.
I'll reserve. Thank you.
All right. And we'll hear from you a little later then. And Attorney McMillan, you'll have 15 minutes then.
Thank you, Your Honor. Well, one thing about which perhaps Mr. Murphy and I can agree is that this should have been a simple case. One thing about which Mr. Gamble and I definitely agree is that Elyria's aggressive litigation tactics were the cause of the expenses incurred here. But before I get into that, I want to clarify one point with the court. Mr. Murphy's argument on behalf of Mr. Thomas is based on a flat mischaracterization of the record. Let me read from the affidavit that Mr. Thomas signed in order to induce Protective to provide financing to take the construction lender out of this project. This affidavit is being made by the owner, capital O, described below, and the undersigned, collectively, whether one or more referred to as the affiant, capital A, for the express purpose of inducing the lender described below to fund the loan. The undersigned was Mr. Thomas. Owner shall mean Elyria Company, LLC, and Ohio Limited Liability Company. Throughout this litigation, Elyria and Thomas have mischaracterized the nature of this affidavit. The affidavit is not premised upon Thomas's knowledge alone. It did not give him the opportunity to remain deliberately ignorant of what was going on in this project and make averments to Protective in order to induce it to lend $3.28 million to replace a construction financer on this loan. Because Mr. Thomas was signing the affidavit on his own behalf and on behalf of For Elyria, he was charged with knowledge held by Grant Giltz, who was admitted to be the boots on the ground, held by the money guy and anybody else who was acting on behalf of For Elyria. He was charged with that knowledge when he signed the affidavit. He represented, based on that knowledge with which he was charged, that there were no outstanding claims for payment, when in fact there were multiple claims for payment. And he was charged with that knowledge up through the effective date of the loan documents, which was March 27 of 2017. During the time that he was negotiating these loans, during the time when he should have been gathering and making representations based on the knowledge of the representatives and agents who have been admitted to be agents of For Elyria, there were claims for payment by contractors on November 30th, 2016, the day that Mr. Murphy claims Brexton waived all of its rights and that For Elyria and Thomas should have been assured that there would be no further claims for payment. That was followed by claims for payment on December 2nd, December 16, December 21, December 29, February 6, February 14, February 21, February 28, March 3, March 16, and then on April 6 and 7 when Brexton filed its mechanics lien. What was the damage to Protective? The damage to Protective is ongoing because For Elyria has yet to discharge the property liabilities on this project. They fought the mechanics lien, even though the contract expressly provides that liens must be bonded off. If For Elyria wants to challenge a property liability, a tax, a claim by Brexton that they should be entitled to payment, they're entitled to do so without it causing a default under the loan documents. But once a lien is filed, the game changes. That lien must be bonded off. For Elyria failed to do that here. They could have done it for perhaps a 10% premium, $50,000. Instead, they ran into court. They filed frivolous claims against Brexton for fraud and other aggressive tactics, prompting Brexton to bring Protective in as a defendant in a foreclosure action and causing Protective to incur legal fees as a result. That's the damage that started. That damage is ongoing because as we speak, Brexton has a foreclosure action pending not on the mechanics lien, but on the judgment lien that the trial court awarded. Whether that judgment lien was proper or improper, we took no position below, and we did not need to take a position below. For Elyria's obligation to bond off Brexton's lien was absolute, and it was incurred the moment that For Elyria was made aware that Brexton had filed the mechanics lien. Thomas's affidavit was false because For Elyria had knowledge of multiple contractor claims that had not been satisfied. It was not For Elyria's purview to say, we don't have to disclose any of these obligations because we plan on taking care of them or fighting them. They had the obligation to disclose them and they failed to do so. What should have been a straightforward matter between a borrower and a lender was complicated by Appellant Thomas's refusal to honor the commitments made by Protective Life Insurance Company, by himself and Appellant For Elyria Company. Had For Elyria simply done what any other owner would have done in these circumstances, bonded off the lien and then challenged it to kingdom come, you and I would not be having this conversation. I would not be here. When this case started, I begged Mr. Murphy to just bond off the lien and told him he would never see me again. Well, here we are. Instead, Thomas and For Elyria dragged Protective through years of litigation, incurring hundreds of thousands of dollars in attorney fees and expenses, which appellants are contractually obligated to reimburse. Mr. Murphy mischaracterized Protective's burden as requiring that Protective show fraud or an intentional misrepresentation. No such burden exists. Once it is demonstrated that the representations in the borrower's affidavit are merely incorrect, not fraudulent, not intentional, just incorrect, that triggers an obligation by For Elyria, that triggers obligations by Thomas as the affiant and guarantor to cover any recourse loss that resulted from those misrepresentations, those incorrect representations, and that is exactly what the trial court imposed here. For Elyria could have stopped the incurring of attorney fees at any time. They could have bonded off the lien. They chose not to do so. They didn't bond off any liens until, and I realize this is outside the record in this case, they bonded off the lien.
Objection then, but go ahead.
Yeah, we're limited to the record. So if it's outside of the record, we're not going to be able to consider it.
All right. So, well, what the record does reflect is that during the pendency of this litigation, during the pendency of the underlying case, and during the pendency of this appeal, there is no evidence in the record that For Elyria or Thomas ever bonded off any Brexton lien, judgment lien, mechanics lien, or otherwise. And because of that, Protective's attorney fees continue to accrue. They're accruing today as we speak, and frankly, as I speak. For Elyria and Thomas remain responsible for all of those because they all go back to the incorrect representations made by Thomas on his own behalf and on For Elyria's behalf, that there were no outstanding claims for payment at the time that Protective extended a $3.28 million loan, having been so induced by For Elyria and Thomas on the incorrect promise that there were no claims pending. That damage persists not only in connection with the attorney fees, but with the impairment of Protective's lien priority, with the fact that the title to the property over which Protective should have a freely transferable lien is clouded. Those damages persist to this day. The trial court also correctly determined that Protective was entitled to an award for the entirety of the attorney fees incurred both by Calfee Halter and Griswold and by Squire Patton Boggs. For Elyria and Thomas made the argument below and in this court that the attorney fees that were incurred by Squire Patton Boggs were not incurred on behalf of Protective. That is also incorrect. First American, the title company, was never a party to this case. They could have been joined, but they were not required to be joined. For Elyria and Thomas have in this case conflated the right of subrogation with the duty to subrogate, and there is no such duty under the law. To accept For Elyria's and Thomas's argument that First American was required to be named as a party would require the joinder of every medical insurer, whoever paid medical expenses for someone who was hit by a car. They have rights of subrogation. Absolutely they do, and absolutely First American did. But there is not an obligation by that insurer covering expenses to join the case. Those expenses were paid to protect Protective's lien, not any right by First American. This is no different than any other insurer obligation to pay, which may be recovered either by the insurer or by the insured. Here they were recovered by the insured. And in any event, irrespective of whether First American was joined as a party to the case below, it makes no difference because the trial court correctly determined that the expenses incurred by Squire Patton were properly payable by For Elyria and Thomas. Whether those were paid to Protective and then later paid by Protective to Squire Patton Boggs, or whether those expenses were paid directly to Squire Patton Boggs or to First American. It makes no difference. They all flow back from the incorrect representation by Mr. Thomas in the borrower's affidavit, which he made on his own behalf and on behalf of all of the knowledge that For Elyria was charged with. For Elyria and Thomas also made arguments with respect to alleged duplication of liens, but the record is replete with demonstrations that included testimony from myself, from Andrew King at Squire Patton Boggs, from Gary Johnson, our expert at Western Herd, and my former colleague Bill Coughlin, that the tasks between the lien priority issue and the remaining issues of the case were segregated and parsed out between Calfee Halter and Squire Patton. The case was handled efficiently and it was handled appropriately. It would have been handled less expensively were it not for Elyria's and Thomas's litigation tactics, but they brought that on themselves. Those strategic decisions are their responsibility, and the legal fees that resulted from them are their contractual responsibility. If there are no questions from the panel, I will cede the rest of my time.
Judge Hensel, any questions? No, and Judge Sutton, any questions for Attorney McMillan? All right, thank you, sir, for that argument. So Attorney Murphy, you've got your 5 minutes. Don't forget to unmute.
It's difficult to respond to that argument because a lot of it is, again, misreading the facts, misreading the law, misreading the contract. They want to put knowledge in Dave's head that just isn't there. And I don't know how else to respond other than to say that in a general way. I am a little distressed that they talked in terms of disclosing settlement efforts. The fact of the matter is, I asked them more than they asked me, what are you doing here? Why are you at the deposition? Why are you incurring legal fees? And I never got a valid answer. Their legal fees were not incurred on matters of novelty. It was a priority issue, and they win. They've got priority. There's no difficulty. There's a statute right on point. There's no skill involved. They really didn't have to do anything. A phone call and a couple of stipulations would have resolved everything. There's no amount involved in this case other than their fees. And they got no results. If Protective had done absolutely nothing, this entire, 6 years we've been fussing with this case, they'd be right where they are today. First and best loan. They haven't, the contract says if they do collection efforts, they get legal fees. This isn't collection efforts. This is legal fees. If they enforce their rights, they get legal fees. They're not enforcing their rights. If they were foreclosing, if they were calling the loan, if they were seizing property, now they're enforcing rights. They're just running up legal fees. If you accept Brexton's, again, back to Exhibit 50, if you accept, Protective's argument in this case, okay, the corporate knowledge was a sworn affidavit from the contractor that there was nothing going on, right? If you accept that, then what happens to commercial construction in the state of Ohio? I think the world collapses, and here's why. Every owner takes these every day. And if an owner takes this fraudulent affidavit and then gets a loan, he's defrauded his bank. Now, how many owners are going to do that? How many banks are going to loan on that? You cannot fault Elyria for taking an affidavit signed and notarized that said everything was paid. If not, we've got a problem. And common sense tells you this. The owner paid almost $370,000 because of this fraudulent affidavit. $370,000. Which owner in this room would pay $375,000 if they really felt there was an issue? Nobody does. Anybody's going to strong arm their contractor by saying, hey, I'm not going to give you $370,000. I think we better talk about what's going on here. The owner was blindsided with a $500,000 bill months later. It's very clear in the Galvin deposition, months later. We would ask that the court conclude that Elyria did not breach any contracts, Protective or Brexton, and enter judgment across the board in Elyria and Dave Thomas. I'm available for questions because I think I have a little bit of time left.
Yeah, about a minute left. Do you have any questions, Judge Hensel? And what about you, Judge Sutton? All right.
Thank you again for your time and attention.
Yes, well, we, on behalf of Judge Hensel and Judge Sutton, we want to thank each of you, Attorney Murphy, Attorney Gamble, and Attorney McMillan, for very good arguments, as well as agreeing to participate by Zoom. We appreciate that as well. As you know, the court's going to take this matter under advisement. We've got a lot of work to do. You've raised some great arguments here that we need to consider, and we will issue a decision in due course. The clerk of courts, as you all know, will mail you a copy of a decision on the day it's released, and the opinions are also posted on the Supreme Court of Ohio's website. Again, we thank you for your arguments today. The court will next convene on March 3rd, when we will have additional arguments but we are adjourned for today. You all have a great day.
Thank you, Your Honors. You too.
Thank you, Your Honors.
Thank you, Your Honors.